Welcome to Medmarc's webinar series. Today's presentation is titled 1 Year Later, the PrEP Act and COVID-19. I'm Kate Klaus, staff attorney in Medmarc's Risk Management Department. On behalf of Medmarc and today's presenter, Jordan Lipp, thank you for joining us. Jordan Lipp is a litigator who has enjoyed wide-ranging success both in the courtroom and through motion practice. He wrote the book on product liability law in Colorado, specifically Product Liability Law and Procedure in Colorado, second edition, and he is an adjunct law professor at University of Denver's Sturm College of Law, where he teaches outdoor recreation and ski law. He was previously a partner at Davis Graham and Stubbs. Mr. Lipp has received numerous recognitions for his work, including being previously named by the Colorado Civil Justice League, Colorado's Tort Reform Coalition, as the Colorado Lawyer of the Year. Mr. Lipp is a graduate of the University of Michigan School of Law and the University of Colorado at Boulder. And with that, I am pleased to turn things over to Jordan.
Hi, everyone, and thanks for joining us for this. It's hard, I'm sure, for all of us to imagine that we're already 1 year in to the pandemic. So just focusing us in first on the PrEP Act and COVID-19. So I gave a presentation with Medmarc on this topic just about a year ago. And so the point of today's presentation is going to be to basically take a look and see what has happened when it comes to the PrEP Act over the last year. Now, most of you are already going to be familiar with the PrEP Act, but I just want to do a quick overview for those of you who are not. In a nutshell, the PrEP Act provides a very strong liability shield for manufacturers, distributors, providers of countermeasures meant to combat COVID-19. So that's the point of it. For those of you who are curious, it's actually a fairly short statute. It's federal statute, so it's only a few pages long. You can find it at 42 USC section 247D-6D and 6E. So for anyone in this area, it's definitely worth reading the statute itself. So with that quick introduction, I want to talk briefly about what's happened over the last year. And then we're going to move back. We're going to look at a few definitions, and then we're going to go carefully through all of the events of the last year in the PrEP Act and what that will mean then as we think about liability risk and reducing liability risk as we move forward. So first, as probably most people on the call know, back in mid-March of 2020, the Secretary made a declaration of a public health emergency as to COVID-19, which activated the PrEP Act. Since that time, we have had 7 amendments to that initial declaration. We have also had 6 advisory opinions from the Office of General Counsel and how the Office of General Counsel is interpreting the PrEP Act and its various declarations under it. When it comes to litigation and case decisions, there have been about 30 now, and the number is going up at a rate of 1 a week, decisions on the PrEP Act as to nursing home and assisted living facilities cases. And we'll talk more about these in a few minutes. But in a nutshell, these are the wrongful death lawsuits against nursing homes and assisted living facilities where the decedent died presumably of COVID-19, and their heirs are suing the nursing home or assisted living facility for having inadequate countermeasures and inadequate protection, and the nursing homes are defending them based upon the PrEP Act. So we have all of these cases, case decisions already from federal courts around the nation on the applicability of the PrEP Act to nursing homes and assisted living facilities. And then I'm sure everyone here is the most curious about, well, what are the product liability decisions we've had so far under the PrEP Act as to COVID-19? And the answer is nothing. We are 1 year into the pandemic, and we have not had a single publicly available court decision applying the PrEP Act in the product liability context. So probably the second biggest question for everyone who is attending this webinar is, well, what about decisions involving medical malpractice other than the nursing home and assisted living facility case? What about the doctors or the pharmacists who may be being sued, whether it's a vaccination error or a ventilation error alleged or that? So the answer as to the amount of cases for that one, also we've seen nothing but crickets. There has not been any decisions that are publicly available on the PrEP Act. Now, to put this into perspective, there is even a decision from the last year as to whether a wage claim, a defense to a wage claim, can be the PrEP Act. And for those of you who know me on the call, right, I am as defense oriented as you get. And even I don't believe that the PrEP Act protects a healthcare facility when they're being sued for allegedly violating minimum wage. And no surprise here, the one decision on that has said that yes, the PrEP Act does not protect healthcare entities when they're sued by its employees as to minimum wage. But this is astonishing, right? That we are now 1 year in, we have all these nursing home and assisted living facility cases and virtually no other cases on what anyone who's attending this webinar would be interested in or what people would care about. So that brings us to the big question. Is the PrEP Act actually working as it was intended to work, right? And I mean, for those who attended my webinar a year ago, I said the PrEP Act provides an extraordinarily strong liability protection. It's not without its exceptions, it's not without its potential holes, but the intention of the PrEP Act is to keep drug, device, biologic companies from being sued. It's to doesn't provide quite the same protections when we talk about physicians and other healthcare providers, but it still provides some pretty strong protections for healthcare providers as long as it involves the use of covered countermeasures. Still, we're not seeing case decisions. So has the PrEP Act succeeded? Are we safe now? Or are we just waiting for the other shoe to drop? And that's really going to be the primary question that we're going to be addressing throughout this webinar. So let me back up for a few minutes and let's talk first about a few of the key terms so we're all reoriented and thinking about the PrEP Act in the simplest way. So there's really two key terms to remember under the PrEP Act. There's first is a covered person. And the covered person is the person or entity that is protected by the PrEP Act. And this is defined fairly broadly under the PrEP Act. It applies to manufacturers and distributors. And I'm using some loose language here, but those related to manufacturers and distributors. It also applies to providers. The term of art under the PrEP Act is qualified persons, but basically it applies to licensed healthcare professionals and others as designated in the declaration by the Secretary. And then there is a third group of covered persons, and I would think of this as the government and related entities. The term of art under the PrEP Act is the program planners. But those are the three groups that are covered and protected by the PrEP Act. But then the PrEP Act is specific to the administration or use of a covered countermeasure, right? So the other key definition under the PrEP Act is what is a covered countermeasure? So a covered countermeasure is a drug, biologic, or device that's meant to combat the declared pandemic. Here, the COVID-19 or the transmissions of SARS-CoV-2. So what devices, what drugs, what biologics fall within that? Well, first of all, it's um, the drugs that are approved, the medical devices that are approved or cleared, and the biologics that are licensed. And so in general, right, we're talking about the drugs and devices that are already out there on the market being used, but now are being specifically used as to COVID. Right, we can think of all sorts of the devices that would easily fall into that category. The second category is investigational products, whether INDA, IDE, but products that have gone through that process with the FDA but have not yet received approval or clearance or license. But then the third one and the biggest one is emergency use authorization products. And this is a term, right, that those of us even those of us in the industry, we knew about before COVID-19, but it wasn't a term that was thrown around every day for most of us. And I think virtually all of the lay public now is familiar with the EUA process and the FDA authorizations for emergency use of various products. So when we're talking about whether it's the vaccines, the ventilators, the COVID-19 diagnostic tests, most of these are the products that fall under the EUA authorization. So that's probably going to be the biggest group of covered countermeasures. So hopefully everyone's with me, right? So the PrEP Act provides liability immunity for covered persons for their administration or use of covered countermeasures. And all of that was more or less well defined as of a year ago, though we'll see how that plays out in the cases and the amendments since then. One other thing to note is that per the PrEP Act itself, there is one and only one exception to the grant of immunity. There's only one way that an allegedly injured party can bring a claim against a covered person, and that is by showing willful misconduct. And just as a brief reminder, willful misconduct is a very high standard. We're talking about a standard that's explicitly higher than negligence, higher than recklessness. When we're talking about a manufacturer, there is even an obligation to show an FDA enforcement action that's been concluded in certain ways to even be able to bring willful misconduct claim. And then if one is bringing a willful misconduct claim, there are a series of procedural hurdles that the Act has placed. So by way of example, the case can only be brought in the federal court in DC. There's a 3-judge panel that hears a motion to dismiss. Even if the case gets past a motion to dismiss, there are damage limitations, there are pleading rules. It's a high procedural and merit burden. So the PrEP Act, of course, has given this great protection for the industry that's helped the industry respond so well to the current pandemic. But the PrEP Act also does provide a different style remedy. And so some of you may be familiar with the, well, it's technically, I think, titled the Smallpox Vaccination Fund, but the Vaccination Fund. And the PrEP Act works in the same or a similar matter. It's called the Covered Countermeasure Process Fund. Even though the PrEP Act was first enacted back in 2005, the fund wasn't set up until 2010. Now, Department of Health and Human Services doesn't, or at least I'm not aware if it does, keep separate statistics based upon which pandemic, which public health emergency we're talking about for compensation under the fund. But there are certainly a number of claims that have come in based upon the current COVID-19 pandemic. But the statistics that the Department of Health and Human Services makes publicly available goes over all claims. And so they've had 550 claims as of March 1 to the fund. Most of those were not eligible. A decent size number of those are currently in the medical review process. So are not part of the statistics yet. But of the ones that are eligible for compensation, 10 of them, they found no compensable loss, but of the remaining 29, there have been payments of over 6 million. So the fund is operating and it is paying out, and we're in the millions now for people who were harmed by covered countermeasures. So just a quick update on the fund side of the PrEP Act. So I thought with that information out of the way, let's talk about the amendments to the original declaration. And just, this is a refresher for almost everyone, but the PrEP Act only applies if the Secretary of the Department of Health and Human Services makes a declaration of a public health emergency. And then the Secretary gets to define in that declaration all sorts of little details about defining what is the scope of the PrEP Act cover. That was done back on March 10th of 2020. And the first amendment, which was in April of 2020, added NIOSH-approved respiratory protective devices to the list of covered countermeasures. The second amendment, so we're moving forward to June, was the first one that in my mind was really interesting. The Secretary expanded the scope of covered countermeasures to those that also treat non-COVID-19 diseases if it helps to fill a shortage of COVID-19 products, right? And we can all remember that time frame late last spring when there was a shortage of, in a lot of places, medical devices that were being used both to treat COVID-19 and to treat seasonal influenza and all sorts of other medical conditions. And so the Secretary expanded the definition of covered countermeasures to beyond just those specific to COVID-19. The third declaration follows that up and is also interesting. So about the same time, right, we were seeing childhood vaccination rates plummet for the routine vaccinations. And so as a result of COVID-19 and people not wanting to go out and go to their doctors and get their children vaccinated and be in public settings. So the Secretary expanded the declaration once again in the third amendment to include all routine childhood vaccinations as covered countermeasures. With that, we started to see a slight change from the Secretary, which is interesting. We'll talk more about this in just a second. The PrEP Act has a preemption provision, right? And when the first time I ever read the PrEP Act, I looked at the preemption provision, and just to back up, I'm sure most people who are watching this webinar are familiar with preemption, but it's the supremacy clause of the U.S. Constitution. It says that the federal law, when there's federal law and state law both on the same subject, under various times, the federal law controls, right? The federal law preempts state law. And so we had an express preemption provision in the PrEP Act. And when one reads that the first time, certainly the way I read that was to prevent state tort lawsuits, that you can't have a state law that provides a recovery against a manufacturer or a provider when the PrEP Act prohibits it. But what happened with that third amendment was that the Secretary took that preemption provision and said that the PrEP Act overrides state law in terms of who is allowed to prescribe childhood vaccinations. We'll get back to this in just a second as we get to later amendments. So let me talk about the Fourth Amendment for a minute. So the Fourth Amendment is really the key one. And if you're going to read no other amendment, that's the amendment to read. And part of it is there were so many changes in the Fourth Amendment that the Secretary republished the declaration with all the changes from April through December. So with that Fourth Amendment, there were so many changes, but let me hit the major ones for you. First, it incorporated the advisory opinions of the Office of General Counsel. And there have been 6 advisory opinions from the Office of General Counsel. Like most advisory opinions, right? They have that typical advisory opinion language of this is just discussing our current views and it's not binding, it doesn't have the effect or force of law. But interestingly enough, the declaration, which is in the Federal Register and does have the force of law or at least should under the PrEP Act, now incorporates the advisory opinions. So it seemingly makes these non-binding advisory opinions now binding. So that was the first interesting thing from the Fourth Amendment. The next one, and sorry to go a little bit into the federal law weeds here, but the Fourth Amendment said that combating COVID-19 in the PrEP Act involves, quote, significant federal issues, unquote, under the Grable decision. Now Grable was a 2005 U.S. Supreme Court case, and I hope I'm saying this right. I'm pretty sure it was a tax case. But the point of Grable was that if a case, even if it's a state court case, if it involves enough federal issues, it should be a case that can be removed from state court to federal court. So in this Fourth Amendment, the Secretary made it plain that the PrEP Act falls under Grable, and PrEP Act cases are significant federal issue cases that should be removable to federal court. The next thing the Fourth Amendment said, which is also a big deal, is if you are not administering a countermeasure, that can fall within the PrEP Act. So the classic example of this, and this is one of the examples that was used in the Fourth Amendment that we all know from personal experience right now, is the vaccination decisions of who gets the vaccine, right? We have a limited supply, and where does it get allocated and where does it not get allocated? And so if for example, provider is deciding to give the vaccine to the patient who is more in desperate need of it than the patient who is less, the decision to not give it to the patient who is less in need of it, that is covered under the PrEP Act. It's the non-administration of a countermeasure. Another piece of the Fourth Amendment of interest is in the original declaration, there was some somewhat unclear language, but it was on distribution channels. And the original declaration said we have two different distribution channels. One is anything related to the federal government and federal contracts broadly defined. And the second one is the products are coming through an authority who has jurisdiction under the authority's orders. And that was the authority having jurisdiction was broad and probably applied to most things, but there was still that open question there. And this is really an important question because there's a time limitation to the PrEP Act's coverage, which goes out 4 years, or depending upon the distribution channel, at the end of the time of the public health emergency under the authority having jurisdiction. And so the Secretary amended that section to also add private distribution channels. So we're not talking about just the authority having jurisdiction in the federal contracts, but also private distribution channels. And then also in this Fourth Amendment, there was the piece about telehealth. And we're all very familiar with telehealth, especially today, 1 year into the pandemic, so to speak. But the Secretary included telehealth under the coverage of the PrEP Act. And again, this may have preemptive effect. So now let's turn to the Fifth, Sixth, and Seventh Amendments. And an interesting question, right, is between the Fourth Amendment and the Fifth Amendment, we have a change of administration. And Secretary Azar is obviously no longer there. We have an interim secretary. And so, but we have continued in the Fifth, Sixth, and Seventh Amendments under the new administration to see an expansion of the PrEP Act, though maybe not in the same way that we saw in the first four. The Fifth, Sixth, and Seventh Amendments have all expanded the definition of who could administer the vaccine. And this is probably at least as important in its impact on state regulatory law as it is under what I focus on, product liability defense. So these amendments all expanded the definition of who can administer the COVID-19 vaccines. So for example, healthcare providers whose licenses have expired in the last 5 years, so long as they meet certain qualifications and criteria, can now administer the vaccine. If you're licensed in one state, you can go to another state and administer the COVID-19 vaccine. And these amendments are all preempting state regulatory law to the contrary. So the PrEP Act has turned into not only this liability protection, but also this method that the federal government has had to preempt state law regulations in terms of who can provide vaccinations. So those are, in a nutshell, what we have seen from the federal government in terms of the changes to the PrEP Act over this past year. So with that, I wanted to go into the case law. And to really talk about the case law, we have to expand our horizon not only to COVID-19, but also to every decision under the PrEP Act. So with that, there is one, and to date, only one product liability case involving the PrEP Act, and this involved the H1n1 vaccination. I spoke about this case briefly a year ago. I actually want to spend a little bit more time on it today because it's particularly important for the manufacturers and distributors, as it's still the only case that we have. But first, before I dive into the Keller v. Hood case, I wanted to talk for just a minute about when I'm showing these screens and what are the decisions. Remember, these are court decisions that are publicly available. So we are not looking at every lawsuit. There have been lawsuits filed that we have just not seen any decisions yet that involve the PrEP Act and COVID-19 in terms of product liability claims. Just for a quick example, there was just by way of example, there was a case filed in the PCCP, the Philadelphia Court of Common Pleas, against a hand sanitizer company, a manufacturer, and the hand sanitizer company removed the case to federal court in Pennsylvania. And one of their primary defenses is the PrEP Act. So that's one of the cases that's ongoing, but we don't have any decisions in that case yet. So the only case that we've had that's a PrEP Act case that we have a decision for is the Keller case. So in Keller, the plaintiff sued his physician, Dr. Hood, and her employer for injuries that he sustained from the H1n1 vaccination. The suit was in state court. The doctor and her employer brought a third-party product liability claim in that lawsuit against Novartis, the vaccine manufacturer for the H1n1 vaccination. Novartis removed the case under the federal officer removal statute to federal court and immediately raised the defense of the PrEP Act. Once Novartis has raised that defense, in essence, basically all parties just had to concede that Novartis was covered under the PrEP Act and that no claims could move forward. And the judge agreed. And as there were no willful and wanton claims filed in federal court in DC in front of a 3-judge panel against the vaccine manufacturer was dismissed. So, of course, the next question is what's left? There's still the Medmarc action, right? So we'll get to that in a minute because I kind of want to go through because we have 3 Medmarc cases that are not sort of the nursing home mal cases. So let's talk about all of those. And I'm going to take them in chron order. And so let's take the most recent one first. These are all H1n1 vaccination cases. Casabianca is the most recent one. This is only a state trial court decision, so very little precedential value. No precedential value, not much influential value, but it's out there and publicly available. In Casabianca, the case was a failure to give the H1n1 vaccination to the plaintiff. And the New York trial court said, look, the PrEP Act is about the administration or use of covered countermeasures. The vaccine here was not given So the PrEP Act does not apply because it was not the administration or use. Now, as you'll recall from a few minutes ago, when we were talking about the Fourth Amendment, the Department of Health and Human Services has said, no, the whole point of the PrEP Act is sometimes we have to decide who gets a product and who doesn't get a product. So the PrEP Act applies to those decisions, and it can apply as much to the non-use of a countermeasure as it can to the use of the countermeasure. Interestingly enough, in one of the advisory opinions, which remember under the declaration should have the force of law, explicitly says that the Casabianca decision, quote, was wrong, unquote. But it's out there. So something for people to be aware of. The second case is Parker versus St. Lawrence. Now, Parker is the only appellate case as of today that has ever been decided under the PrEP Act. Also involving the H1n1 vaccination, there was a kindergartner who was inoculated for H1n1 without parental permission. So the parents sued on behalf of the child for battery and other claims, saying that the kindergartner should not have gotten vaccinated, and sued the public health department who administered the vaccination. The New York State Trial Court dismissed the case based upon the PrEP Act. The case was appealed to the appellate court in New York, and the appellate court affirmed the dismissal. The appellate court agreed that an H1n1 vaccination was covered under the PrEP Act, and that the PrEP Act prevented the lawsuit against the public health department. So our one appellate case predates COVID-19, but kept a health department who provided vaccination from getting sued. Which brings us back to the Keller versus Hood case that I was talking about a minute ago. So what happened once the vaccine manufacturer was out of the case? Well, the federal court said it didn't have jurisdiction anymore to decide whether there was PrEP Act immunity for Dr. Hood and her employer. And so the federal court, without deciding one way or the other on the PrEP Act, remanded the case to state court. Well, it's an interesting decision because virtually all the litigation that we have seen so far today has been on this removal issue in the nursing home context. So if you'll remember earlier on in the presentation, I showed this is the list of all of the nursing home and assisted living facility cases involving the PrEP Act and COVID-19, and there are a lot of them. Now, this slide is a little busier than it actually should be, or arguably should be. If you look through here, you might notice that in almost half the cases, it's the same defendant, Big Blue Healthcare Inc., located in Kansas. And indeed, a bunch of these decisions were issued by the same judge on the same day. So as we look through these cases, it's not quite as numerous as it looks. I'll explain in a minute why I've made Garcia far and away the largest and Hatcher the second largest. But let me talk us through these cases for a minute, because they all follow the same pattern. So there is a nursing home or assisted living resident who contracts SARS-CoV-2 and dies allegedly as a result of that at the facility. And the heirs sue the facility, claiming that there were inadequate controls in place to prevent residents from getting COVID-19. There were not enough temperature checks, the staff weren't properly trained, there wasn't sufficient use of masks, there wasn't sufficient COVID-19 testing of the residents, et cetera, et cetera. And in all of these cases, except the Hatcher case that we'll talk about in a minute, in all of these cases, the defendant, assisted living facility or nursing home, removed the case to federal court based upon the PrEP Act. And then the question became, was that removal proper? So let's think about and talk about removal for just a second. As most of you know, right, if a case gets filed in state court, there's the primary basis to remove a case to federal court is diversity jurisdiction. That is, that the defendant and plaintiff are not located in the same state. This is a huge tool for getting into federal court in product liability lawsuits, because we'll just use Colorado, where I'm from, to keep it simple, but there are not that many medical device and drug companies based here in Colorado. I mean, there are quite a few for a state of our size, but primarily they're not based here. So if a company that's based in Philadelphia or in Massachusetts gets sued here in Colorado, I have the ability to remove the case to federal court under that diversity jurisdiction. That's usually less available in cases involving medical malpractice, though sometimes it still is. And in fact, considering the increase of telehealth and the use of healthcare providers to cross state lines to provide vaccines, we'll probably be seeing more diversity cases in the Medmarc context. But it's certainly a large area in the product liability context. But in these nursing home cases, it's almost never available. So what are the bases to remove that are potentially PrEP Act significant? Well, the first one is the one that we talked about a few minutes ago, and that's the Grable decision from the U.S. Supreme Court. If there is a substantial federal question, then there is presumably the basis to remove the case to federal court. That's the Grable decision. That's the Fourth Amendment to the Declaration. It's also in the Fifth Advisory Opinion from the Office of General Counsel that the PrEP Act provides this. And of all the decisions on the screen that have considered it, which is most but not all of them, there's not been a single court that, as of today, has found that a case is removable, a PrEP Act case is removable under Grable. Grable hasn't been working yet. Hopefully it will start working soon. The next one is complete preemption. Complete preemption is when there's a federal law that so completely covers the field that there's no room in any way for state law to apply anymore. ERISA would be an example. The World Trade Center litigation would be another example. The Fifth Advisory Opinion from the Office of General Counsel said that the PrEP Act creates complete preemption. Most cases on this list have disagreed. The one big exception, Garcia, we'll talk about in a minute. The next possible basis for removal, right? So I talked about diversity, substantial federal question, and complete preemption. The next one is the federal officer removal statute. So the federal officer removal statute is basically when the federal government directed the defendant to take an action, and that action had as a causal relationship with the plaintiff's claim, and there's a federal defense to that claim, then you have the federal officer removal statute. That was the basis for Novartis to remove successfully the Keller case, the H1n1 vaccination case, but that has not been successful in any of these nursing home assisted living facility cases as a basis to remove. But with that said, I want to talk specifically about Garcia first, because Garcia is a big deal. It's the one case so far where in a nursing home context where a federal court has agreed with the removal and said removal was proper under complete preemption. And because removal was proper, the motion to dismiss the nursing home filed was also proper and dismissed the nursing home case under the PrEP Act. So that's the first one. Hopefully we'll see more, but Garcia is a big deal because it's the one case that came out enforcing the PrEP Act in this unusual nursing home context. The other case I want to talk about briefly was Hatcher, because Hatcher was actually brought to the federal court on the basis of diversity. So the question, unlike all these other cases, was not the propriety of removal, the propriety of whether the federal court does or does not have jurisdiction. Rather, the question in Hatcher was just simply, does the PrEP Act apply to the case? The defendant moved to dismiss the case based upon the PrEP Act, and the federal court in Kansas said no, that these nursing home style claims are not really about covered countermeasures and the administration of use of them, and the PrEP Act does not protect the nursing home defendant. So three quick caveats that I wanted to give about the nursing home decisions that we've seen so far. So the first one is to remember a lot of these cases were only decided on removal and nothing else. Some of them said, well, it doesn't look like the PrEP Act applies here, so removal is improper. But a lot of them said removal is just improper, but the PrEP Act may or may not apply, and I'm not going to make a decision on that, right? That's what we saw in the Keller case, and a lot of these decisions say the same thing. So when a case is back in state court, that doesn't mean that the PrEP Act doesn't still apply. It does, of course, right? The only decision that is out there at the appellate level so far on the PrEP Act is a state court decision enforcing the PrEP Act. So just because the case is in state court doesn't mean that the PrEP Act may not still apply. The second big thing to notice is these cases are, I think in the words of the decisions that have gone against the defendants, tangential to covered countermeasure, right? These are not the same type of cases as allegations that a COVID-19 diagnostic test had a false negative or a false positive that caused injury, right? That would be much more of a classic PrEP Act case. These are cases that don't really deal with covered countermeasures in the same way, and they're certainly not product liability cases. And then the third caveat that I wanted to say on all these cases is many of them are currently on appeal. So that includes the Garcia case, and it includes a lot of decisions remanding the case to state court. So 6 months to a year from now, we will have a much better idea once circuit courts have started weighing in on the PrEP Act's applicability in the nursing home assisted living wrongful death. So very briefly, just for the sake of completion, again, PrEP Act does not prevent an employment wage claim case. We have one decision on that. So with this background out of the way, and sort of we've caught ourselves up to date, what does this mean? What should we do? Well, hopefully a lot of this has provided a lot of information from the risk assessment and underwriting standpoint, right? We know there are not many PrEP Act cases being filed, or cases of product liability, even provider outside of the nursing home cases being filed so far. It's a good indication. But of course, as we know, statute limitations vary from 2 to 6 years. The other shoe could still drop. But hopefully this talk so far has given everyone a good sense of where we stand from a risk assessment and underwriting standpoint. But the question is, so if you're a manufacturer or a distributor, what are the concrete things that you can do to help increase your ability to get that PrEP Act coverage? Besides making sure that your attorney, if God forbid you get sued, is really up on the PrEP Act and making sure that that's the lead-off defense. The first thing, and this may seem obvious, but it is very important, is the question: is your product a covered countermeasure? Are you distributing a covered countermeasure? Now, it is helpful because the declaration and the advisory opinions have provided some good language saying, well, if you intended to, or it's close to being a covered countermeasure, it should be. But of course, we don't know whether courts are going to follow that language yet or not. But so question number one, is your product a covered countermeasure under the PrEP Act? Does your product actually fall under an EUA or not? And that's an important question. And the second question is your product, is it meeting the labeling and the other EUA authorization requirements, right? And we've all seen these authorizations, and some of them are very lengthy. And to help lower the risk, making sure that the product is as compliant as possible with the EUA is certainly going to be helpful. The third thing that I would just remind everyone is, because I've gotten a lot of questions about this, that the PrEP Act, it's a United States statute. And I know many folks on the call, right, you're selling your products, not just in the United States, but all over the world. And as I've spoken with my colleagues in other countries, right, the PrEP Act is a US statute, and most other countries don't have the same protections that we have as to this. So those are just some of the first items to be thinking about. There's going to be the whole issue about bringing back these products or making sure that they are disposed of properly once the pandemic is over. So keep your eyes on that issue too, as hopefully the pandemic is winding down in light of herd immunity and the vaccines. So think about that. Well, what about providers, right? What can a healthcare provider do to help increase his or its ability to have protection under the PrEP Act? Well, I think that the simplest one is just good charting, right? Make sure that your medical records are memorializing the use of the covered countermeasures. And there's nothing wrong in fact, it's probably good to literally call them countermeasures, covered countermeasures, or pandemic product. And if you remember, right, this is the Casa-Bianca versus advisory opinion dispute that we talked about earlier. Does the non-use of a covered countermeasure get protected under the PrEP Act? Well, one of the best things that you can do to protect yourself is make sure that you're charting. If you are not using a countermeasure, why not? And that you consider to do it, but in an ideal world, because of allocation issues, you were not able to use that. So those are some of the thoughts I have from the provider standpoint in terms of what we can do to help fall under the PrEP Act. But in the end, a lot of this is just going to be good litigation in the unlikely or unfortunate event that you face a claim or lawsuit. So I want to gaze in the future a minute and talk about what we may see that's coming up and what we may not. And when I do this, I'm always very mindful of that great Yogi Berra quote. I'm going to paraphrase it: that never make predictions, but if you're going to predict something, predict the past. And so I'm going to violate that rule now, but bear in mind, I do not have a crystal ball. But let's talk about the future. And by the way, I like this cartoon image, but this is plainly not me with that clear vision to the future, because this cartoon character has a full head of hair, and I have almost no hair left on my head. And his hair is a wonderful reddish brown, and the few hairs that I do have left are rapidly turning gray, or my daughter would say turning white. So let's talk about what does the future hold for the PrEP Act? Well, first things first, 1 year in, we have not seen an explosion of product liability claims. That's a good sign. And it's probably indicative of something, right? Think about this. We have seen claims against manufacturers of countermeasures that are securities lawsuits, right? You said you could provide X product and to your investors, and you didn't, and your stock is falling because of it. We have seen breach of contract lawsuits. You said you're going to provide X products, you didn't. We've seen sort of the false claim lawsuits between manufacturers and distributors, but we haven't seen a large number of product liability lawsuits. So using that as a gauge, hopefully the PrEP Act is doing exactly what it was supposed to do, letting us focus on making good products without having to worry about lawsuits, and creating a fund that will compensate those who are truly injured by a countermeasure without them having to use the litigation system and tying up manufacturers' time and money and insurers' time and money in defending these cases. The next piece, of course, that we have to think about with this is, is some piece of this the halo effect as well, right? And there's been a lot of jury research about this, that the life science industry is what's getting us through the pandemic. And so jurors and attorneys have a positive view today about the life science industry. And may that mean that some attorneys are more afraid because they think a payoff is less likely to bring lawsuits, and that may play into that to some extent. But hopefully, in addition to that, because we don't know how long that halo effect will last, the PrEP Act has been the primary deterrent for more lawsuits. So far, PrEP Act is working as it was intended to work. Let's hope that keeps up. perhaps we'll do another update on the PrEP Act in March of 2022. Hopefully by that time, the pandemic itself will be a distant memory. We will all be out seeing each other in the restaurants and bars and traveling everywhere. But if there is that update in March of 2022 on the PrEP Act, let's just hope that we're not seeing any more product liability or provider lawsuits. But once again, we're looking into the ball here, and that's always a difficult job. So with that, thank you, everyone, and I look forward to the questions.
Thanks so much, Jordan. We do have a few questions for you from our listeners. First, this question sort of gets into what is included in the definition of a covered countermeasure. So if a company is producing a class 1 510K exempt device, so they don't need any kind of pre-market clearance or approval prior to selling the product, how can they ensure that they are preserving PrEP Act protections? Do they have to market the product specifically for use in COVID? If that's the case, would that maybe potentially change their regulatory status, requiring them to gain clearance? What is the best, easiest way to get their product out there, but ensure that if it is used to treat COVID patients, that they are doing what they can to preserve the PrEP Act shield?
Okay, so the most sure method, though this may not always be available and may be somewhat prohibitive or may not work, right, is just getting the UA authorization, right? I'm talking now as a product liability defense attorney and not a regulatory attorney, right? So as a product liability defense attorney, right, it's simple. Just you go out and you get the UA authorization. So the question is, what if you can't? And then we're talking about a device that has not been has not gone through the 510K clearance. Well, you know, the PrEP Act isn't terribly clear on this, and there's certainly an argument that the other side would have in that case that the definition. So when we talk about covered countermeasures, that includes a qualified pandemic or epidemic product. And that pandemic or epidemic product is defined as something that's approved or cleared or licensed, among other things. So that there's sort of an open question there. And then, of course, when we talk about labeling for or not for COVID, we get into all those other issues about whether that is proper under other FDA laws. So the easy answer is get an authorization, but I know that that's not always as easy as it is for me to just say that.
Okay, thank you. Has the US government responded to any claims under the PrEP Act to date? I know we've discussed this a little bit. It was a question that had come up, specifically litigation around COVID-related products.
Not that I'm aware of in the products context, but boy has the federal government responded in these nursing home cases, right? So when I was putting together this presentation, right, there's the chicken and the egg. Do we talk about the cases first, or do we talk about the amendments first? So to the extent it was lost, when I was talking about the amendments, we hadn't yet talked about the cases. A lot of those amendment issues dealing with advisory opinions and Grable were all specifically in response to the fact that the first few of those nursing home cases had been removed, and the federal courts were saying, no, I don't have jurisdiction here. I'm remanding the case back to state court. So at least certainly under the last administration, we've seen a very strong response from the federal government. There's been at least one amicus brief in a federal court filed by the U.S. government supporting removal, and so at least in the last administration, very strong support for the nursing homes and assisted living facilities from the U.S. government. We'll have to see where it's going to be from the new administration. Though it is interesting, I should point out, because I didn't talk about this during the primary part of the address. So the PrEP Act has a provision that the amendments to the declaration cannot take away the immunity previously afforded. Now, it's a quick clause. It's never been interpreted. We don't know exactly how that will play out, right? And I think that's a lot of people think that the new administration will be as anxious to use and have a robust PrEP Act as the old administration. But if that's not the new administration stance in a few months, it's unclear how much they're actually going to be able to take back. But I know that the second half of what I said is a little off topic, but hopefully that answered the question.
We have another question that relates to clinical trials for products that would later be considered covered countermeasures. Does the PrEP Act need to be mentioned in the informed consent? The typical wording is usually that signing the consent form does not waive the subject's right to sue. Would the sponsor of the trial want to include information about the PrEP Act in the wording of the informed consent so that the subject is aware of this particular shield for the manufacturer?
That is a great question, and I hate to do this, but I need to think about that a little longer, and go back to those informed consent rules. There's certainly nothing in the PrEP Act that says that you need to do it. There's no specific language in the PrEP Act on that at all whatsoever, but that's a question I need to spend 15 minutes looking at or respond. Sorry.
Okay. Nope. Thank you. We understand. And it might be something that would be appropriately addressed with the IRB as well. And one last question. Does the PrEP Act extend to contract manufacturers of potential covered countermeasures? Could you talk a bit about that?
Yeah, no, that's a great question. So the term manufacturer in the PrEP Act, it says manufacturer includes, and just a brief aside for those of you, I don't mean to legally geek out here, but include is a great word in any statute because Black's Law Dictionary defines include very broadly. But anyways, it includes, and then there's a list. So it's not only the manufacturer, it's also a contractor or a subcontractor for a manufacturer, a supplier or licensor of any product, intellectual property, service, research tool, or component or other article used in the design, development, clinical testing, investigation, or manufacturing of a covered countermeasure, and any and all parent subsidiaries, affiliates, successors, and assigns of a manufacturer. Is that the broadest list we could think of? No, right? I can think of statutes that have a broader list than that, but that's a pretty broad list. So, we obviously have no court opinions yet interpreting that language, but it should include most different types of manufacturers. There's a contract manufacturer, a component part supplier, or anyone in the chain. And let me just briefly mention as well, there's also a separate definition for distributor, and that one also has the includes language, and it's also very, very broad, and it goes as far as including air carriers. So FedEx is going to be covered in a PrEP Act case if they say that they're flying out the vaccine and the vaccine gets too warm, right? No cases on this yet, but that's the intention of the PrEP Act. So manufacturer and distributor are very broad.
Okay, great. I think that is the end of the questions. So Jordan, thank you very much for this update to last year's series. This is a topic of great concern to our audience, and I know that your presentation will be valuable. Thank you for joining us. This concludes today's webinar.